Right, good morning everybody and a very warm welcome to the very wet Rottenstall branch of Pearce Accountants. I hope you're all keeping well in this very strange environment that we're all inhabiting and working within. Today we're going to talk about something very salient, which is business risk and how you go about protecting it. Fundamentally, what is business risk? I looked it up on the internet to seek a definition, and the best one that I could come up with is business risk is any exposure of a company or organisation that may cause its profits to fall or cause the business itself to fail. Who am I? I'm Ben Smith. I'm a director in the Pearce Group of companies. I actively manage a portfolio of clients, a particular speciality, say for being a jack of all trades and master of none, is strategic planning, structuring, R&D claims, and for my sins, I also am one of the people who goes overseas with various clients. So I think it's worth, before we look at why we're going to, or how we go about protecting our assets, is to identify and think about some of the different types of business risk. Business risk is always specific to the business and market in which you operate, but there are some various broad headings that encompass different elements of it. So taking 5 that we've collated together here: strategic risk. By way of example, if a competitor decides to undercut the market from a pricing strategy, for example, Aldi and Lidl are becoming very prevalent. They offer decent quality goods at a significant cost reduction compared to main supermarkets. So from Tesco's perspective, even Asda's perspective, they're being undercut and their market share is being taken away. Compliance risk. An example, failing unknowingly to adhere to import duty. Now, I had this example with one of my clients perhaps 7 or 8 years ago now, and he ended up with a 6-figure import duty bill. Given that we are in the midst of leaving the European Union and without a confirmed trade deal between the EU and the UK, and indeed the UK and other parts of the world, that's a fairly high risk at this particular standpoint. Hopefully there will be some fairly seamless transition rules, but nonetheless a risk for those who are both importing and exporting. Operational risk. Again, an example, providing too much credit to a customer who subsequently fails, and bad debt risk, particularly prevalent where there is one particular dominant customer within your customer base. Their failure could have very significant impacts on your own business. Financial risk. Borrowings obtained that cannot be serviced any longer. We have a very relevant example at the minute. There's been an awful lot of CBILS loans being taken out. And let's face it, none of us know what the future exactly looks like. So there remains a risk that whilst the loans are being provided, that they might not be capable of being repaid in, say, 12 months' time when the business is looking somewhat different to perhaps it looked before February of this year. Last one, reputational risk. Again, an example, Huawei being kicked out of both the UK and the US from a network standpoint. Huawei are also retailers of mobile telephones, and there will without doubt be some element of impact upon their retail sales as well as their network support. Those cover some of the key risk areas in terms of headline, but it becomes very much dependent upon your own business and understanding and analysing those risks. So fundamentally, accepting that all businesses are pregnant with a degree of risk, what are we fundamentally looking to protect? And there are 2 things. Firstly, the personal assets of business owners, so your homes, cash that you may have acquired, investments, and also the corporate assets of limited companies. And what am I talking about principally there? Talking about accumulated cash balances beyond that which the business needs to trade. Secondly, property prospectively. And thirdly, the assets that are integral to running your business. So if you're a manufacturer, the plant and machinery that you've got is ordinarily absolutely critical to the ongoing success of the business. So we're looking at both personal assets and also corporate assets of limited companies. Pulling matters right back to basics for a minute, there are 2 particular ways that you can operate a business. Firstly, as what we call a sole trader, and secondly, as a limited company. And I think it's important at this juncture to recognise that there are different types of structures, but there are also relative advantages and disadvantages. So a sole trader business is, in essence, you operating as an individual. You might engage staff, but fundamentally, the debts are fundamentally in your name. And let's not make any bones about it, there are some advantages to it. They're easy to set up. From a compliance perspective, they're cheaper to run, and they also afford greater privacy. One of the key downsides, which I'll come on to in a moment in relation to limited companies, is that as part and parcel of having the benefits of limited liability as individuals, we have to publish on Companies House various statements during the course of the year, and also, of course, your accounts in some element of format dependent upon your business size. However, there are also some very significant disadvantages to being a sole trader. Firstly, and primarily, your personal assets are not ring-fenced from the risk of the trade, and owners are personally liable for the debts of the business. So let's just come back by way of example to the bad debt risk. Let's assume that you were operating as a sole trader. You had a £30,000 bad debt, and that represented your entire debtor book, and you had £20,000 worth of trade creditors that you'd taken out in supplying those services. Irrespective of whether that debt was collected or not, you are personally liable for paying that £20,000 to your trade creditors. Second aspect, there is less flexibility regarding tax compared with a limited company. And also, I don't think that we should forget that there's an important perception standpoint from both customers and suppliers. If you're a limited company, the perception is that you're more serious about business, that you're respectively a greater size than you actually are. And all of those things are conceptually important in the marketplace. So moving on to limited companies, advantages, and the key one is financial liability is with the company rather than the individual. There are certain caveats to that, which I'll cover at the end, but that is the critical piece. Coming back to the bad debt example, in the event that that £30,000 bad debt was not paid, the £20,000 payable to the trade creditors is a debt of the company, and it may force the company to close, but it is not affecting you as an individual. Secondly, there's improved perception. Again, coming back to you're respectively a larger business than you actually are, and there are also greater flexibility regarding tax planning. 10 years ago, the tax planning and remuneration structure was far more advantageous operating through a limited company. The revenue have and or the government have in the past 5 or 6 years sought to close the gap between sole traders and limited companies. Nonetheless, there remains a tax advantage. Disadvantages, however, public disclosure of some financial information, again subject to size, greater cost to run because limited company accounts and the compliance aspects are more onerous, and there's a greater administrative burden that needs compliance. So a limited company has an awful lot of attraction, but it needs to be offset against some of the cost aspects. So just ratcheting back to the focus of today, the asset protection on sole trader versus limited companies. Sole trader, personal assets are not ring-fenced from the risk of the trade, and owners need to be very mindful that they are personally liable for the debts of the business. From a limited company standpoint, financial liabilities with the company rather than the individual. So the single point of recommendation, if you are continuing to operate as a sole trader, is you may wish to consider incorporating your business to protect against future business risk. So let's assume that you've now incorporated your business from sole trader to trading company. You've traded your trading company for a number of years. The business has been a success and you've started to accumulate surplus assets. Okay, what do I mean by surplus assets? I tend to mean, firstly, trading property that you might have bought, which isn't subject to mortgage anymore. I mean cash surplus to trade requirements. Again, what do I mean by that? It might be that the business as a limited company has, for example, £400,000 worth of cash, but only needs to have £100,000 of cash available to trade unfettered. So there isn't concerns about paying trade creditors on time and so forth. So we've got a £300,000 surplus. Lastly, plant and machinery, typically, again, coming back to the manufacturing example, where you have plant and machinery that's integral to the business possibly not a surplus asset, but one that you wish or might wish to protect. Now, there is a very simple solution to protecting those assets, and it's by declaring a dividend to the shareholders. However, there are two key risks. Firstly, significant personal tax liability. So when you declare a dividend, depending upon where your income tax, or forgive me, total income levels sit for that year, the personal tax liability is probably somewhere in the order of 32.5% to 38%, which isn't particularly attractive, especially if you want to reinvest in the business over the course of the next 1, 2, 3 year period. And there's also prospectively corporation tax liabilities on taking some of the assets out, particularly in relation to property and plant and machinery. So again, coming back to protecting assets, what are the alternatives? There's an alternative to protecting accumulated wealth in a trading company, very simply by establishing a parent company to the trading company. In English, what does that mean? It means that the shareholder or shareholders of the trading company effectively give up their shares in the trading company in return for mirrored shares in the parent company, and the parent company owns 100% of the trading company. So Pierce's client base is very much small and medium-sized enterprises, very often owned by husband and wife team, and they would be shareholders in the trading company initially. We would put a parent company on top, and they would have mirrored shareholdings at this level. What does that then allow us to do? It allows us to transfer accumulated wealth from the trading company to the parent company, and in so doing, protecting the assets from the trading risk of the business. Those transfers are also tax-free. Now, I know we've got a IP in the room today. You'll be chuckling right now. There is a caveat to this because a time period does need to pass. And nonetheless, it focuses your mind that it's prospectively worth doing sooner rather than later. What are the advantages of doing so? Ring-fencing key assets from risk without incurring personal or corporate tax liabilities. Secondly, flexibility in terms of creating new businesses through new subsidiaries of the parent company. So it might be that you have a particular venture at this particular point in time but want to explore going down a different business route. You can create a new subsidiary company of the parent. As one company as you start up, you've got some losses in this company and you can give them over here. It gives all sorts of flexibility to you. Thirdly, and this is becoming increasingly common, flexibility in terms of establishing joint venture or similar arrangements. So you can have your corporate entity as your parent company owning a proportionate share of a business or limited company and introduce a third party without having to, want a better phrase, bugger about with giving shareholdings in your existing trading businesses. Again, we need to be even-handed. What are the disadvantages? There's a modest cost of implementation, which is very easy to justify on an offset basis, which I'll come to shortly. There's an additional company to administer from a longer-term standpoint. And let's again not beat about the bush. It does not ultimately resolve the tax position on value extraction. So business owners want to enjoy at a particular juncture in time the rewards of their efforts, the sacrifices that they've made, the hard work they've put in, and this doesn't enable at this particular junction you to extract the cash without incurring the personal tax liability. It does, however, allow you to store it up, and it allows for a disposal mechanism at a future juncture. The process for implementation is actually very straightforward. A clearance letter needs to be submitted to HMRC. Fundamentally, what the shareholders of the trading company are doing in giving up their shares in return for newly issued shares in the parent company, it is technically a capital gains tax event. But you're receiving paper for paper, and there is a clearance mechanism to ensure no capital gains tax liability arises. The revenue have statutorily up to 30 days within which to respond. Before coronavirus, the typical turnaround time tended to be around 2 weeks. It has slowed down over the course of the past 4 months. The clients that I look after, I've put in perhaps 3 or 4 applications over the course of the past 4 months, and they are taking right up to the 30 days. Once we've got clearance, and providing it's a bona fide commercial reason, there's absolutely no reason why the clearance will be denied. We then need to make the parent company ready. What do I mean by that? Get the bank accounts open, register it for VAT if so required, getting group insurance expanded out, and so forth. Actually, the longest piece in all of this tends to be opening a bank account. Without wishing to criticise the mainstream banks, even opening credit accounts where you're an existing customer can take a 6 to 7 week period. So that it actually tends to be the slowest piece in all of this. Thirdly, some legal documentation is required to facilitate share-for-share exchanges. Again, I know we've got a solicitor in the house today, so no doubt they'll be able to share their experiences with that later. And then we get to completion. Whilst it may look complicated, trust me, it's not. I haven't got a Scooby-Doo how to lay bricks, but we do know how to deal with these aspects of people's business affairs. So it's horses for courses. I think it's important to address what I call pub myths. I was down the pub one day and my mate said this to me, which is a common problem that we all have. So let's address some of the common questions and perceptions. So first question, why don't I wait until my business has problems to do this? Okay. Fundamentally, there's something called antecedent transactions. In English, it means that in the event that your business fails, for whatever reason, and a liquidator is appointed, the liquidator has the ability to look back initially for up to a 2-year period prior to the insolvency event, in particular relation to connected party transactions, so whereby cash has been moved, whereby property has been moved, whereby plant and machinery has been moved, and they can seek to prospectively unwind those transactions in order to put the creditors back into the position that they would be had you not made those transfers. So what is the key message coming out of this? And this particular question, it means plan now. Do it now. Don't wait until you've got a problem. If coronavirus has taught any of us anything, none of us had a crystal ball 6 months ago, but we perhaps are more highlighted to the fact that things are going to come left field to businesses and will continue to come, hopefully not with this severity, and we simply don't know what the future holds. Second question, I have got insurance, why do I need this? And again, we've got a first-hand case. Many businesses take out business interruption insurance, which means in English that a sum of money is paid by the insurers to the company in order to either replace turnover or more typically gross profit. However, the first thing that many business owners did in late March, early April was contact their insurers, and the underwriters simply said that they do not cover pandemics. So you've taken out business interruption insurance on the expectation that there will be a sum of money coming to the business to replace lost revenue and lost profit, and your insurers won't cover it through the small T's and C's. Let's be brutal about it. Fundamentally, insurers don't want to pay out and will not insure you against the failure of a trade. So again, we are looking to protect in your parent company all of those key assets and all of those surplus assets. Thirdly, I don't want to pay the cost. Fully get that, fully understand that, but let's look at a payback period for a minute. So let's assume as a business owner that you take out profits each year equivalent to £100,000, but your company's made £200,000 and you want to take a dividend of the extra £100,000 in order to robustly protect it. The effective tax rate on that dividend between £100,000 and £1 and £200,000 is, when you work it out, in the order of 42%. So for that £100,000 that you're withdrawing, you're getting £58,000. Particularly if you want to reinvest to grow the business, it doesn't make a right lot of sense, in my opinion, to dilute the available cash to reinvest by that £42,000. Accountancy and legal costs to implement the parent company structure are typically in the order of about £4,000. So in 1 year, there's a tenfold increase by taking the dividend route as opposed to the parent company route, and it starts to stack up from a numbers perspective. Next question, is it morally acceptable? And this is one that often comes up. In credit to our clients, and they want to settle people out, and I fully get that. and all credit to people for their behaviour in that way. However, as always, there are counters to that argument. Is it morally acceptable to your family not to seek to protect the assets you've worked hard for, and more than likely with owner-managed businesses made personal sacrifices for? Is it morally acceptable not to position your business to continue to trade with its key assets if it fails? What do I mean by that? If you've got plant and machinery and we haven't protected it, then we'd necessarily need to buy it back from the liquidator if we could afford to do so. If we haven't got the assets, we certainly haven't got a business, and we certainly can't continue to employ those who have supported the business for many years. Put very simply, there is no right or wrong answer. It's simply business. But a prudent measure, in my opinion, remains to put a parent company in place if you've got those surplus assets and key trading assets to protect. With some other hints and tips, not necessarily linked to parent companies or indeed incorporation, but some broader hints and tips as to things that you might want to contemplate. So, actively and continually appraise the risks faced by your business and develop strategies to mitigate them. Certainly don't sit on your laurels expecting that everything's going to be okay. Risk crops up out of nowhere and from the least expected quarters, and we need to continually be on top of it. We all have the habit of getting embroiled into the day-to-day matters, but it's important to step back and think about the business more broadly and ensure that you've got the risk mitigation strategies in place. Second tip, maintain copies of all your insurance certificates. They are not subject to the 7-year record rule. By way of example, and this is a real life case for one of my clients, there had been various PII matters regarding firstly asbestos, then it was hearing claims, then it was dust ingression into the lungs. One of my clients had a former employee who gave up their employment however long before bringing about a claim from 25 years ago, and they couldn't find their insurance certificate. So company is effectively liable, as I understood matters. So keep hold of your insurance certificates. You won't remember in 10 years' time who your insurer was in 2020, let alone 25 years ago. Watch out for personal guarantees and parent company guarantees. So we've got the veil of limited company protection, but that can be breached by way of entering into a binding legal agreement whereby either directors provide personal guarantees and or the parent company provides a guarantee. Typically linked to borrowings by and large, unless you are got a particularly good relationship with your funder, they tend not to relent on them, albeit they may put a cap on them. Supplier credit terms is a very frequent one that I come across. So you have a trade account with Travis Perkins, by way of example. They tend to have personal guarantees attached to them in the event that the corporate entity fails and there's a balance standing on account to them. Thirdly, leases. So where you lease premises and or lease plant and machinery, there are occasionally personal guarantee clauses included within them. Next one, regularly protect your profits. What do I mean by that? So we've put a parent company on top and we've got your trading subsidiary on the bottom, and you're making profits nicely and evenly in a nice perfect world in your trading company, and you seek to protect it once a year. It's okay. However, the better thing to do is on a quarterly basis at minimum. And let's say, ratcheting back to the example that you've got £100,000 surplus profits each year, do 4 lots of dividends of £25,000 each from your trading company to your parent company. The reason that I say that is that you don't know necessarily what timing the event that is going to cause difficulties for your business is going to arise. And it comes back to the antecedent transaction point, and also in particular what information you had available at that particular juncture to justify that your business was solvent and could declare that dividend lawfully. You should also prepare appropriate paperwork. Again, what do I mean by that? Board minutes and dividend vouchers to transfer the assets from the trading subsidiary up to the parent company. Again, people say, well, the paperwork could catch up. Yes, it could. However, again, from first-hand experience, litigators are bright. and they ask for what they call the metadata is of the paperwork attached to the dividends. So fundamentally, when you create an electronic file on your computer, whether it's Word, Excel, whatever it is, there's effectively a date stamp on it when that file was created. And they want to get back to that point to show that you were trying to do it retrospectively. And I've been on the brunt of defending a client who did that with a one-eyed litigator, which was a very unpleasant morning, let's put it that way. Secondly, consider other mechanisms to protect your profits. So one very good example is pension contributions. I know we've got an IFA in the room today, Andy. So again, looking at different mechanisms to protect your profits. Pension contributions, not only excellent from a corporation tax standpoint, not only excellent from a provision standpoint going forward, but also is a vehicle in which to prospectively protect some of your profits. Thirdly, consider protection mechanisms if the parent company loans monies to the subsidiary. What am I talking about here? Let's assume that we've accumulated 3 years of the £100,000 worth of profits. So we've got £300,000 in your parent company, and you want to make an investment in your trading subsidiary. So one mechanism of doing that is then loaning the monies from the parent company back down to the trading company. Fundamentally, what the parent company is at that point is a bank. It's lending money to it. And under commercial scenarios where a third-party lender loans monies to an entity, they want what's called security. And we can afford exactly the same security mechanisms to subsidiary companies in relation to parent companies as a third-party funder would. It is critically important, however, to get that debenture in place before the monies are advanced. It's a relatively simple procedure. Again, the solicitors in the room today will be able to confirm that, but it is a very, very prudent mechanism to protect your monies on an ongoing basis. So we'll come on to questions in a moment, but just to summarise the presentation today, the past 4 months have caused us all to reflect upon how we possibly want our businesses to look on an ongoing basis. As part and parcel of that, and augmented in all of our minds, is protecting the assets from the trading risk of the business, which has been presented to us fully over the course of the past 3 or 4 months. So the first thing to consider is, if you operate from a sole trader perspective, you may wish to give some thought to incorporating your business in order to protect you against the future risks that it might hold. Secondly, having developed your trading business and within a limited company environment, and in the event that you're starting to make some surplus profits, you may wish to consider establishing a parent company in order to protect 3 things principally. Firstly, property. Secondly, surplus cash. Thirdly, plant and machinery integral to the business. Fourthly, there are some generic points to make sure that you continue to administer the business parent company correctly, but also mechanisms that you've already got in place, but you can perhaps wish to refine. Lastly, as with all of these things, it's worth getting advice upon them. There's always the pub company myths that we come up against, but absolutely we can assist in providing some advice initially on a no-cost basis to support you with businesses going forward. So that largely concludes the presentation from my perspective this morning even. We're not yet this afternoon. If anybody's got any questions now, by all means, we're very happy to answer them. Indeed, I might get a solicitor and IFA and IP on board with some of the responses if need be. If in the alternative you prefer any questions at a latter juncture, by all means, we're always available to assist you. Lise, do you want to take on?
Yeah, I have put in the chat box if there are any questions. No one's typed any in yet, but if you have, just unmute yourself on the left-hand side and feel free to ask away.
Excuse me whilst I have my coffee now.
Can I just ask you a quick one? Can you hear me?
We can, John. Yeah, go ahead.
How secure are contributions to company pension schemes, such as, say, by attack from a liquidator in the future failure of a business? If, say, in the example Ben gave there, £200,000 profit, you paid £100,000 out. If you then say, well, let's do 2 £40,000 contributions to the pension scheme for the husband and wife, and the company fails a couple of years later, is that money always secure in a company pension scheme?
Would you like to unmute Ian, Lisa?
Yeah.
So by way of introduction, Ian is a insolvency practitioner. Don't boo too loudly, but he'll be able to give the defined answer.
Well, firstly, thank you for that warm introduction, Ben.
This wasn't planted either, Ian. Sorry.
No, no
we might all need you at some stage, Ian.
Well, hopefully not, but I'm on hand to help if need be. Hopefully, if you do need me, it'll be a many solvent liquidations and winding up for tax efficient purposes. Just coming back to John's question, it very much depends on the context. Typically, if you're making routine pension contributions throughout the course of the company's life, they are as close to watertight as you're going to get, and they will be protected from the reach of a liquidator. However, the antecedent transactions that Ben mentioned, excessive pension contributions is one of those that is explicitly stated in the Insolvency Act, and it very much depends. So if, for example, you made that pension contribution of £100,000 3 weeks prior to a liquidation, you've done it purely in contemplation of putting an asset out of reach of creditors. If it's something along those lines, then it can be overturned. If, however, it's a reasonable pension contribution done throughout the course of business or done at a prudent point when there's no contemplation of insolvency, then you should be protected.
Right. Yeah, that's pretty much what I thought. But no, that's fine. And I just wondered, clients often ask, "Oh, well, I paid into that pension, and if I go bust, how safe is that? Can they come back for that years later?" But as you say, if it's regular and in proportion to the level of profits that you're making, I guess it's pretty safe, isn't it?
Yeah, that's exactly it.
Yeah. Right. Yeah. Good.
Lisa, you're on mute.
Yeah, no, sorry, my child just walked through the room.
Any other questions?
I don't really have a question, Ben, but I think it is worthwhile just picking up on a couple of points that you made. So my name's Phil Stevenson. I'm the lawyer that Ben has referred to on a couple of occasions as we're going through. First of all, it's worth pointing out that it really is as straightforward as Ben has described. There is inevitably a degree of legal work involved in setting up the new parent company and swapping the shares into it. But it is straightforward. And in terms, I was interested by the moral point that you made, Ben, in that being a lawyer, I haven't got any, but but I think it is worth pointing out that the system is very much set up to accommodate it. The transfer of shares from you as individuals into the new parent company in exchange for the shares that are issued to you by the parent company is open to relief from stamp duty. The transfer of assets from the property up into the parent company again is open to relief from stamp duty. The whole system is set up in such a way that having the parent and subsidiary in place is entirely normalised and is not subject to any taxes at the point in time when you set it up in place to discourage you in any way from doing it. So it's almost as if you're expected to. So why wouldn't you?
Okay, thank you.
Yeah, can I just add to that as well? Just one last point. If you were considering a company buying a property, would you generally advise that was bought through a parent company? Start with.
I would. Obviously, when you're buying a property, the principal creditor is going to be the bank. The bank will take the security over it anyway, unless you've got the cash in which to do it. But it does have big advantages in terms of putting it beyond the reach of creditors, and again allows you to manage the relationship with the trading company by putting a lease in place and extracting rental income from the the trading company. I know a lot of clients. Will actually put their property into the pension fund.
Yes.
You know, rather than a parent company. That's also worth considering, but you would do that for different reasons.
Yeah, that's good. Thank you.
Ben, could I just make one small point just to add to the areas that you've covered? I found it really useful this morning from a structural point of view. I hope this doesn't sound like I'm flying the flag a little, but I really don't intend to. 25, 30 years ago, when I was involved with Pierce, we did an awful lot of shareholder protection cover, key man insurance, etc. And during the lockdown, in particular, I've had a number of inquiries about that, and I'm just wrestling with one at the moment that's an enormous figure, the largest cover I've ever done for somebody, 12 million. It's a fascinating area, and one that I find particularly fascinating, but I'm sad where that sort of thing's concerned. I haven't done pensions for 20 odd years, but I particularly enjoy that aspect of the business, and there is so much confusion and very little real, shall we say, client knowledge on the subject. And I just thought it should be worth mentioning, because obviously we spend a lot of time protecting our business assets, but we also have to think about other ways in which the business assets can be protected. The main area of confusion, of course, between shareholder cover and key man cover is where the money ends up and where, you know, what the real objective is. And you will no doubt have heard so many people using the terminology in the wrong way around.
Yes.
So I just thought it should be mentioned this morning.
Yeah, it's a very important area in terms of key man insurance, cross option insurance, and so forth. There is also, in touching upon one of the points in here, there is an emerging market for personal guarantee insurance, which I suspect you may have come across, Andy.
Truthfully, I haven't actually.
Yeah,
Tell me more.
There is one underwriter, Purbeck Insurance, at the minute, who are providing personal guarantee insurance, year one up to 60% of the guaranteed amount, year two providing there's no material change in the business, 70%, year three 80%. So there is all of these sorts of insurance areas are critically important. Completely agree with you, Andy. Yeah.
I would imagine that's expensive cover from Purbeck, is it?
Not as expensive as, I'll send you some details, Andy.
I'd be interested.
It's something that I came across probably 12 months ago now, and it is becoming more relevant, particularly where, let's face facts, the high street is retrenching from commercial lending. So there's a whole plethora of new lenders, and personal guarantees are typically being tied into them. One example that everybody's heard of is Funding Circle. Funding Circle are relatively aggressive in the pursuit of personal guarantees, and therefore there's a market developing for it. The premium's actually not as much as you think. I had a quote last week for a particular transaction that we're doing. I'll send you what the percentage is of the personal guarantee. I can't remember what it is off the top of my head, sorry, but it's actually better than you think.
Could be interesting for one or two clients I can think of. Yeah. Thank you.
Yeah. Is that okay, everybody? I hope. Thank you very much indeed for all of your time this morning. I hope that it's been informative, insightful, at least thought-provoking in some regards. As ever, if you need us, we are more than happy, as always, to speak to you, and it's good to see so many people in so many different locations as well. If you've got any queries at all, please, of course, let us know. The next webinar, Lisa, is going to be when, and what's it on?
On the 11th of August, at the same time of 9:30, and it's on making tax digital and the use of online accounting software. And apologies for my daughter interrupting us right near the end.
So, good. Excellent. Well, we shall bid you all farewell. Thank you very much indeed for your time this morning. Hope you all have a good day. And it's lovely to see Eva as well. We'll catch up with you all shortly. All right.
Thank you very much, Ben.
Thanks, everyone.
Bye.
Bye.